Welcome to the first of a four-part series on the collaborative practice of law. The Alabama Center for Dispute Resolution is pleased to co-sponsor, along with the Dispute Resolution section and the solo small firm sections of the Alabama State Bar, the Birmingham Bar Association Collaborative Law Committee, and the Birmingham Collaborative Law Alliance, these free 60-minute webinars. Before I introduce today's speakers, I'd like to cover a few housekeeping rules. We have attendees from around the state joining us, and so we ask that you please mute your phones. This way, we may all hear the presentation without interruption or distraction. And we also ask that you please do not put your phone on hold. If we do these two things, this will help ensure we may all hear the presentation without interruption or distraction. If you're joining us by webinar, you must log in using your name or telephone number so that we may have a list of attendees. There will be time for questions and answers at the end of the webinar. If you do have a question, you may type it in the chat box on your screen or save it for the end of the program. We ask that you identify your name and then state your question. If you're seeking continuing legal education credit with the Alabama State Bar, we would appreciate you completing the evaluation that was sent with the invitation to the webinar. You may complete the survey online using the SurveyMonkey link sent with the invitation. During the webinar, I'll provide you with a code to enter into the survey. This will help with the requirements for the Alabama State Bar to verify that you attended. Again, our webinar is about to begin. Our topic today is the Introduction to Collaborative Practice of Law. If you're just now joining us, we ask that you please mute your phones, and also please do not put your phones on hold. And by doing these two things, everyone may have an enjoyable webinar experience. This webinar is being recorded, and if all goes well, it will be posted at the Alabama Center for Dispute Resolution's website. We are so grateful to the Birmingham Bar Association for hosting the event live today, and to our panelists Virginia Miller, Francis Nolan, and Brian Turner. And so at this time I'd like to turn the webinar over to our panelists.
I am here today with Brian Turner and Virginia Miller, and we have some participants here live with us, and we welcome both our live participants and our webinar participants. We're going to be talking today about collaborative law, and I want to just open by explaining to you what it is. You'll see a slide with the technical definition, but what I would like to do is give you just a brief history of collaborative law. Back in the early 90s, there was a divorce lawyer in Minnesota who was tired of having unhappy clients, no matter how he resolved their cases, whether by mediation, litigation, negotiation, outside of a formal mediation, whatever. He felt like the consensus was nobody was ever happy. So he decided that there might be a solution if parties could negotiate from the commencement of their dispute towards a resolution without so much positional bargaining. And he sort of came up with the idea to call it collaborative law, and he got the blessing of the Minnesota Supreme Court, and he and several of his colleagues began the process of collaborating, which meant that he and his colleagues in collaboration were contracting with their clients to only function in the role of a negotiator. This idea sort of morphed across the country, and when it got to California, they improved on it, and it became an interdisciplinary process involving lawyers, mental health professionals, and financial neutrals, all functioning as a team to assist parties to the dispute in reaching a interest-focused resolution. The cornerstone of collaborative is the concept that you are functioning as a lawyer in a limited scope role. Your job is to assist the client in negotiating a resolution. Your job is not to litigate their case. So if the collaboration fails and a resolution cannot be reached, then you have to withdraw as their counsel, and they have to find someone else to litigate their case. Because this is a limited scope role, it's important that the clients be informed about that and that they consent to that representation. I think that the details of that is a whole nother webinar, and we will address that more specifically. I think it's webinar 4.
Yeah.
Webinar 3 or 4. Yeah. And for those of you who are present with us today, if you want to join the webinars, we have a 4-part series. This is part 1 of the webinar series, and you can go to the Alabama Center for Dispute Resolution to find the details on the other webinars. So one of the first questions that people usually ask is, when should I even consider collaborative as an option for a client? Well, I think that those of us who've been practicing in collaborative for many years now would say that every client should be informed of collaboration as a choice, just like they should be informed about mediation as a choice and negotiation on their own as a choice, and the pros and cons of litigation as well. So it ultimately is a client's choice, not yours. However, I do think that there have been some circumstances, and I'm going to ask y'all to chime in on this, where we have, in hindsight, wished that we had prevented parties from signing up for collaboration.
Absolutely.
Brian and I had a case once that became immediately explosive, and I think what we recognized in that situation is that the parties have to be able to sit in a room together. If they can't sit in a room together, I mean, we're not saying you can't have bad feelings, you can't have an absence of trust, you can't have emotions, but if you cannot sit in a room together, then you're probably not going to have a successful process.
And one of the things, parties, people think that with collaborative law, people have to be, touchy-feely, and it has to be, it's all kumbaya. No, you can be in absolute disagreement about everything you're coming in to negotiate on. The only thing you have to agree about is that this is the process you want to use to achieve the outcome. Any place where there's a relationship that the parties want to preserve. As Francis said, this started in family law, and it's probably most frequently practiced in family law. But there are plenty of other applications, maybe resolving an estate, where you've got to be dealing with your siblings or you're dealing with family members, and there's relationships worth preserving. Business situations, where you want to have a continuing business relationship after the matter is resolved. Collaborative would fit fine in any of those areas. Just because it developed out of family law does not mean that you're stuck having to deal with child custody and estate division issues, and that's the only place that it's appropriate.
It just happens that it has been the most effective and popular in the family law arena, and that's where collaborative law has had the most traction thus far. I think we've kind of covered the next slide in terms of a general overview of when is it not appropriate, but again, where people are not willing to negotiate in good faith, and what I mean by that is we have all had those clients who sit down in our office and say plainly that their goal is to inflict some sort of pain on the other party. Well, that's clearly not appropriate generally in any setting, but it's certainly not going to be appropriate for collaborative. Anytime that you have clients who want to keep secrets, this is not the appropriate forum. We'll get into a little more detail about that, but collaborative is successful based on the fact that we can trust that the parties are going to fully disclose everything that is relevant to the dispute that they have to resolve. And as collaborative advocates, it is our job to ensure that that does in fact happen. Brian and I have had a case where we had clients who had a very, very challenging time articulating their own interests. And I think that the best way to exemplify that for you is you've all had those clients who, when faced with a choice, will say, just tell me what to do. That's probably not a good collaborative case. Emotional, physical abuse, undiagnosed mental health, and chemical addiction problems, all of those can really derail a collaborative process. Sometimes there can be success in those kinds of cases,
and that I was going to say, we've had cases where there have been people who have mental health or dependence issues, but if they're in treatment and they're acknowledging those problems are there and they're following the care plan that's been set out for them by their treating physicians or whomever, that does not rule them out of being able to participate in a collaborative case. It's where the person is ignoring the issue or the substance abuse is going untreated and the person's just not capable of participating. That becomes an issue.
Right. Now I'm going to surrender to you, Brian, and let you, or is it Virginia now? Is it you now?
So one of the things that we often get asked is, how does collaborative differ from a traditional litigation practice? What this is really is a choreographed, structured negotiation process. And what you're trying to get to is an interest-based negotiation process, which is different from the typical positional bargaining we often do in litigation. And my client, and I'll stick with family law for the moment, my client wants the house come hell or high water. Collaborative looks at why. Why is that important? Not the what so much as being in the house, but why? Is it because they need a sense of security? Is it because the children are used to the school system? Is it because there's so much equity involved in the house, or they're upside down in the house? There is no equity. How are we going to find it? Getting to the why behind the interest is the key to successful collaboration, because what you're trying to do is help the parties control their own decision making. There is no judge. There is no jury. You are giving up some of the tools or many of the tools that come along with litigation. That's part of that informed consent, limited scope representation that we mentioned. You are not presenting evidence to anybody else. You're sharing the information between the parties and the team members, if applicable, to help the parties make the right decision. And anybody who's been through mediation training, or anybody who's a mediator or goes to mediation regularly, knows that parties who control their own decision making are happier with the outcome and more likely to comply with the agreement, as opposed to having a judge or an arbitrator jam it down your throat. So you're giving up, the right to have somebody else make that decision for you. Confidentiality. Litigation, everything's in the public domain. Everything you file is a public record. Here, nothing gets filed. Well, one, a collaborative case doesn't have to end in a court order, depending on the case that you're dealing with. Talking from a family law standpoint, nothing gets filed until an agreement is reached, and then just the documents that would be filed with an uncontested divorce are filed. There's no formal discovery out there. There's no transcript. So parties want to keep the negotiation process confidential. This is close to confidentiality, and the records can't be subpoenaed to court if the collaboration falls apart. You're trying to create a situation where dialogue between the parties can occur in the least heated way possible. And we're going to talk a little bit later about the team members when you use a interdisciplinary team. But the idea is to try to take the heat out so that good informed decision making can occur. And there's no you are using neutrals, but you're not using a mediator. I'll get to that in a second. Any professionals that typically we would, in litigation, you very often would hire your own accountant, your own forensic accountant, your own, person to evaluate a custodial arrangement for the children if it's a custody case. Everybody who's going to serve in that role is neutral. They're hired by both parties. That person is not there to be the advocate or the hired gun. That person's there to facilitate the discussion, to gather the necessary information, and to disseminate it back to the parties so that everybody's singing off the same sheet of music. While it's kind of a somewhat trite statement, we are looking for a win-win outcome here. Recently saw an article that talked about one of the reasons lawyers end up hating the practice so much is the one win, one loss, no end game, solutions that we typically are hired to find. I've got to win at no cost. It ends up leading to all kinds of issues for the lawyer in practice. That's one of the things that, the title of this is The Practice of Law Getting Old for You. the zero-sum end game is frustrating. You know, it can be demoralizing to the attorney. It's definitely demoralizing to the parties to, you know, win or lose. Here we're trying to find what's the best solution for this situation. How can we make this the outcome that the two of you can live with and maintain that relationship after the fact? And it's fiscally efficient. I know that's going to lead to some questions potentially when we start talking about team members. But if you think about litigation, you hire a lawyer at the beginning, you hire your experts, you take depositions, you complete paper discovery, you know, you go to, you know, motion hearings, you go to, you know, status conferences, you go to a trial. That trial may take a couple of days. Costs keep ballooning as you go. Collaborative is the opposite. You may have a lot of people at the beginning working on the case, but as their work is done, they drop out. And it tapers back down to where you've got the two lawyers at the end drawing up an agreement. You've got the right professionals at the right rate doing the right work to lead to the right decision. How does collaborative differ from mediation? As a mediator, this was one thing. Collaborative was one of the things that I became interested in because of mediation. Because looking at interest-based negotiation is what I've always tried to accomplish in the mediations I've handled, whether they be a car wreck, whether they be a divorce case, whether they be a business dispute. Here you don't have a neutral third party in the same sense that you have the mediator running shuttle diplomacy between the clients and delivering messages. The clients are communicating directly with the assistance of counsel. Mediators, and this past week I've had 2 pro se mediations, and one of them definitely felt like I was banging my head against the table because they definitely needed legal advice. And I pulled the plug on it, said, you guys have to go talk to lawyers because I can't give you the advice you are searching for here. So you don't, you know, the mediator is neutral, can't give legal advice. Mediation, you know, parties represented by independent counsel. The mediator can't represent either of them. Here, that's a similarity. They have independent counsel, but that counsel is serving in that limited scope of being one of the ways I like to demonstrate it. I used to do a lot of pharmaceutical mass tort litigation. Inevitably, there was trial counsel and there was settlement counsel. You know, you had people working up the cases to get ready to go to court, and you had the people on the other side who were taking the information and saying, okay, now how do we get these cases resolved? Collaborative, you are that settlement counsel piece. That is your role. That's where you're coming in here. You are the one trying to get to the finish line without having a trial. If mediation is done right, I don't necessarily agree with this next statement that parties feel to give up a substantial amount of power to the mediator, but I can see where that perception comes from. I'm letting this person deliver my message. I'm letting this person tell me the offers.
Well, and on that topic, I recently had a case in which a very skilled mediator that I love unwittingly generated a lot of conflict between the parties, and a 10-hour day of mediation did not yield a result, but later a 4-hour sit down with the 2 lawyers and the 2 clients got it done. Because middlemen, even with the best intentions, can push buttons that are unknown on the other side. So you may be abbreviating something, or you may be cutting to the chase, or whatever, and it offends somebody. So I think that's one of the great benefits of collaboration, is that the parties can, without filters, talk directly to each other.
Well, and that, I think, touches on this next bullet point. You know, a mediator does not realize going into the room that I'm about to deliver information that, you know, one party, I've had this happen to me, where one party says, well, go ask him or her about this. And they've done it with the full intention of knowing that's going to set them off. I've not been prepared. I'm coming in and I'm now being jumped because I've even dared bring this up. In collaborative practice, that's where the coaches come in, the mental health professionals. They come in to help us understand you can't barrel headfirst into this topic. You got to come around the side. Here's how the best way is to approach that topic with these people, because this is their hot button. You don't have that, you know, in litigation or in mediation. And like I said, as a mediator, I've certainly had my head chewed off for delivering information that I didn't realize was the hot button. And unlike litigation and unlike in mediation, again, I pause on that with mediation. Here, you really want the parties driving the boat. I try in mediation to talk to the parties as much as possible. If they have counsel with them, that's a filter. You know, the lawyer may not want me talking directly to their parties. I had one lawyer in a case I can think of several years ago when this was a mediation that was ordered at the courthouse. And I said, okay, I would like to speak to your client. They said, no, you can talk to me. I don't know that really complied with what the judge had in mind. But here, the parties are the ones making the contribution. Instead of the lawyer standing in front of the client with the sword and the shield, the lawyer is either standing at their side, assisting them, or standing behind them, giving them a shove forward. I think that's the visual to kind of think of through those two pieces.
Let me just say one more thing about
Sure.
that. Another thing that I think we underestimate is the value of face-to-face communication between parties to a conflict. I think lawyers can often be afraid of that. We have kind of been trained as traditional advocates not to let our clients talk. They'll screw it up. We got to talk for them. And, we've talked about the fact that collaborative is choreographed. And so we do some preparation with clients, and we do sort of help them understand the implications of certain things that they might be inclined to say over others. But one of the things that I've noticed is that clients can sometimes act better when they are face-to-face with one another because they both know they were there whenever the thing that they're in dispute about happened or accumulated or whatever. And while they're alone with their advocate, they might be willing to exaggerate or fabricate or, nurse a tale that isn't exactly accurate. But when they're looking in the eyeball of the other party who also knows the story, they kind of get held in check a little bit. So,
and it's sort of like, with text messaging or email or whatever else, you'll say a whole lot when you're not having to look the person in the eye.
mm-hmm.
Collaborative, you're making somebody look the other person in the eye and have those discussions. Hopefully, as I said, in a setting where we've taken some of the heat out of it. The other thing I think collaborative does is takes away what I call the judge or mediator, the lawyers using a judge or mediator as a cop out. Well, I'm not going to. Yep, I'm not going to tell my client that they have to compromise on that. The judge is going to have to make them do it. No, we're part of good advocacy and part of being good counsel is telling your client when you need to compromise, when you need to give a little to get a little, when you need to back off that position just because by God I want it. Collaborative takes that out because you don't have that judge to fall back on or that arbitrator to fall back on or that jury to fall back on and say, I didn't tell you how to do it. That came from the judge. No, here you are going to have to help your client learn to compromise, and that can be difficult. We're going to move forward into a little bit different topic with how the process actually works, and I'm going to pass the mic over to Virginia, or the phone as it is, so that she can start helping us all understand how this process works.
Hey everyone, I'm Virginia Miller, and like Brian said, I'm going to talk about how does it work. I know we've given a lot of information this morning in the past 30 to 40 minutes about the theory behind how this process is different, but I think everybody's probably kind of like how I was when I heard about collaborative. I was excited, but I was like, well, how does this really work? I mean, what are the nuts and bolts? Like, how do you really do this? And one thing I'll have to say about that, and until you do it one time, you probably, it's like getting on the bike and riding it. You get the concept, but you're not good at it until at least you do it one time. So the first thing on this slide under how does it work states the parties sign a collaborative participation agreement describing the nature and the scope of the matter. Okay, so when do you do that? You usually do that at the first meeting, the first collaborative meeting. Both lawyers and both parties are there, and it's a contract. And the participation agreement is something that we like to go back to a lot. Brian hadn't probably pulled it up, but I'll kind of jump ahead a little bit. Parties are supposed to act in good faith during this process. And so when people start getting out of line and doing things that are outside of the participation agreement, it's like bringing out your contract and you show everybody. You're like, hey, we need to have before we start this next meeting, we're going to bring out this participation agreement. And remember where it says right here that you're going to act in good faith and do this and do that. That's the part that's one of the important pieces of the participation agreement. When the lawyers start saying, how are we going to maybe get this thing back on track? It's where you start to get it back on track. But everybody signs it, and we all go over it at the beginning of the first meeting. That's usually the first thing that we do. And I think we discussed this at a later webinar, but even prior to that, when your client comes in and everybody's decided that they want to move forward collaboratively, you also have I have a separate collaborative contract, because collaborative, as I believe we've already discussed, is a limited scope representation. And so my collaborative contract is completely different than if I'm going to litigate a case. Okay. Moving along. The parties voluntarily disclose all information which is relevant and material to the matter that must be decided. As Mr. Turner said, we do not do formal discovery in a collaborative matter. Usually there is no complaint filed at the beginning. Can be, because you can go, and I'm skipping around a little bit, you can go from litigation into collaborative, but you can't go back as the lawyer with the same counsel. You can go back to litigation, but you can't go back with the same counsel. So normally there's no complaint filed, there's no discovery that's been filed. Everybody, whatever kind of case you're working, whether it's a family case, a probate case, you know what kind of discovery is needed. I mean, you don't have to file the formal discovery to understand what you need. That's part of the reason you file it, because you know you need it. But everybody knows what they are going to need to be able to make informed decisions through the process. Usually, as we all know, in most cases, there's one party that usually has more information than the other. That's part of the reason they're probably having a dispute to begin with. And so that person needs to provide that. And you make a list, and Brian talked about it. There's no discovery filed. You make a list, or you tell people in the meeting what's needed, and then you find out how long it's going to take them. Look, do you need 3 weeks? Don't tell me 2 weeks. If you need 3 weeks, you need 3 weeks. If you need a month, we'll set another meeting in a month, because we can't really move forward without this information. And then they need to let you know if they still haven't gotten that information by the next meeting, because if they don't have it, there's no reason to really waste everybody's time with another collaborative meeting to try to go over those issues.
So, and what that leads to is we're all responsible for holding each other's feet to the fire. That if we set a meeting for 2 weeks, we follow up, and because you are wasting not, maybe just the lawyers, but if you have a financial neutral who's ready to review those financial records and they're not ready, you're wasting that person's time and you're wasting the client's money. So there is skin in the game for the client. They've got financial skin in this game to make this process keep working, and we hold it by scheduling the next meeting with homework.
Well, and I think we're kind of skipping over one of my favorite things about collaborative. It's the financial neutral who collects most of that information. I don't know if you guys are like me, but discovery is like getting a colonoscopy or something. I hate it. I don't want to draft it. I don't want to look at all that crap. So the good news is it's the financial neutral who normally initiates the list of things that need to be produced and goes through them in an effort to regurgitate that information from a neutral's perspective into, data bites that work in the process of moving to the next step.
And if somebody does not voluntarily disclose that information that's necessary, the process ends. The process will absolutely blow up. If you have a client who tells you, yes, I've got another bank account, no, I'm not telling them about it, you as the lawyer have a duty to say, we're done. And all the work product that went into it is kept in the process. It can't be subpoenaed out, can't become non-discoverable. The lawyers, the coaches, the financial neutral, all hands off. You're starting over at square one with new counsel. Good luck, and there's that skin in the game. You've just blown that money that you've gotten at that point because you're not willing to voluntarily disclose that information. That's part of that participation agreement saying you will do this voluntarily?
The next line item under how does it work states the parties agree to use good faith efforts in their negotiations to reach a mutually acceptable settlement. And part of that goes to sometimes in the middle of a case, you know, you might need to make a little temporary agreement or come to some kind of understanding about how something's going to work. Well, in normal litigation, you know, usually you have to go to the judge and get an order. In collaborative, during these meetings, we usually designate somebody to take minutes, and then the minutes are then distributed to the rest of the group afterwards. And everybody has a chance to read them, and if there's something that they disagree with, they need to let everybody know, because that's essentially the understanding of everyone after the meeting's over with. And so
very businesslike.
It is very, very businesslike. It's like going to a board meeting in a lot of ways. And so once you come to some kind of temporary agreement, even though there's not a court order, you've been in the meeting. Everybody's sat there together. Again, what a waste of time and money to have sat for 2 hours. Usually we don't meet for more than 2 hours because we've seen a decline in people's ability to process and function after about 2.5 hours. But you could have potentially paid your lawyer plus a part of the financial neutral or some other neutral that's there assisting in the process, and then you blow the thing up. And so, again, that's part of acting in good faith. And also that will blow the process up. People do it sometimes, and we go back to the participation agreement, and we're able to keep the case on track. But usually a second blow up in a situation like that it usually will result in termination of the process. Frances and I had a case together, and I remember to this day being in the grocery store when she called me to tell me that my client was sort of getting outside the bounds, and I was like, okay, I'm gonna have to have a participation agreement phone call with him about staying on point and acting in good faith. All right, the next line, each party must be represented by a lawyer whose representation terminates upon the undertaking of any contested court proceeding. This, I jumped a little bit ahead, but I think this is a part that lawyers are interested in knowing about. So once I start with you in collaborative, I can't go back with you in litigation. I can start with you in litigation and I can go to collaborative, but I can't, once I go to collaborative, that's it. I can't go back with you. And again, that keeps the skin in the game, because once, like Brian was saying, once you put all this time, effort, and money into paying me and to potentially paying some other third-party neutrals, whatever their role is, whether it be mental health or financial or some other type of expert in a different type of case, then you really don't want to go back and say, oh my gosh, I'm going to have to go back, pay another lawyer, and do all this. It's almost like you're starting over again.
And unlike mediation in some respects, I've certainly had people who come and I felt at the end of the mediation that they were using me as just some easy discovery. That, you know, we'll just ask a bunch of questions, we'll see what we can feel from the other side. They had no intention of settling the case when they came. Doesn't work so well in collaboration, because all that information they got is staying right there. You know, they may have to, they got an idea of what to go ask for now. You may have to start over at square one though, and now you can send out your interrogatories. Now you can send out your request for production of documents. Now you can start issuing subpoenas, but you're not getting the stuff that was actually generated there, and you're going to spend the money to do it all over again.
Maybe. Oh, go ahead. Yeah.
There were just a couple of questions that I saw forming as we were going through. I just want to make sure that I mention those. If a collaboration fails and you go to litigation, Brian was clear about the confidentiality of the collaborative process. However, that does not apply to documents that are coming in regardless. So bank records, appraisal reports, those kinds of things are obviously not going to be excluded, and you're not going to have to necessarily go back and start over to get them. Another thing that I wanted to point out is one of the most confusing things I think about making this paradigm shift into a collaborative role as an advocate is the confidentiality. Brian talked about, you know, having a client who doesn't want to disclose something that is absolutely relevant to this dispute and required by the collaborative process to be produced. Well, in that instance, when the client comes to you and says, I'm not going to do it, you can't violate their confidentiality. So you can't go to the rest of the team and say they won't produce their XYZ. But you have a duty to the process because you signed on as a collaborative advocate not to continue the process with a secret. Just to clarify, because I know that makes people nervous, the idea that you would be violating your client's confidentiality.
Yeah, attorney-client privilege exists, absolutely, but the way you approach things is a little bit different. I know we're going to get into some of that, so I don't want to jump ahead on that.
Okay. The next line item under how does it work, it talks about parties, and y'all have heard us say this a whole lot about engaging third-party neutrals. And like Brian said, instead of being like regular litigation where everybody runs out and finds themselves an expert and it becomes the battle of the expert and which expert is the judge going to believe, you know, no matter what it is, construction case, employment case, divorce case, doesn't matter, whatever. You know, who's going to believe the expert? So in this situation, there's one person hired. And so we're talking about financial experts a lot. There's one financial expert. He's the third-party neutral financial person, usually ends up in the cases I've been involved in being everybody's favorite person. And actually, sometimes we invite the third-party financial expert to meetings, even sometimes when maybe they don't need to be there because they have a calming effect sometimes on the clients, and it's just actually good psychologically for everybody to have their presence there. But usually we decide and designate what third-party neutrals we are going to need and who they could potentially be, usually at the first meeting when we sign the participation agreement, because at that time you're going to know. And I'm going to use a divorce case just because it's easier for me, because that's primarily what my practice is. You know, at that point it's going to be, do we need a financial person? Usually, yes. Do we need coaches? The mental health professionals? Do we need a coach for each person? Because there's different models. Sometimes you can use one coach for them to be able to sort of go through the emotional part of the process with the coach. That also helps them stay on point and helps to keep meetings from being derailed because they have worked through a lot of that sort of offline with the mental health professional. Do we need a child psychologist to come in? Do we need a separate mental health professional for a child, for instance? So those are some of the folks that get decided upon in the first meeting usually. And like this says under how does it work, just like the lawyers, those folks can't testify either. Part of that, and most of that is dealt with in the participation agreement as well. Sometimes we've already decided who's going to be involved prior to the first meeting. And so sometimes those folks are already there and signing the participation agreement as well. It just depends. Okay, the next line item is the parties may jointly engage other experts as needed. I think I probably already talked about that just now a little bit.
Or something like that. If you need a business valuation, one neutral to do that.
And then I've talked about the meeting. So it says the process unfolds through a series of choreographed conversations between the parties, along with a varying configuration of the professional team members, during which specific agenda items are addressed, all with the goal of leading the parties to reach a well-informed, mutually acceptable compromise. And so I said sometimes the financial person's there, even if maybe we don't necessarily need them, just because people like to have them there. I think they like to look at the financial neutral and say, hey, what do you think about this? They're given a lot of deference and collaborative. But you may not need the coaches there. Maybe you don't need the financial person there. If you don't need them, then they don't show up. It's like what Brian said. They don't, even at the beginning of the process, if it's a meeting where we don't think that they're needed, they don't have to show up. So people are not paying for their time. You don't have 7 people sitting in the room, with 4 of them not speaking if they're not needed. We usually designate a person to take the minutes at that meeting. We do. That's right. We have an agenda prior to the meeting. We, usually at the first meeting, we know we're going to deal with the participation agreement and maybe designating the third party neutrals, and we probably don't go much further. We may kind of make an agenda and give some homework for the second meeting. But certainly prior to the second meeting, there's an agenda that is sent out. Everybody reviews it. Everybody knows. If you do not have that agenda, the meeting can definitely go astray. You can get out in the weeds quick without an agenda.
And the agenda is basically based on what do the clients need to address. You know, what is the first thing that needs to be done? This is client driven. This isn't the lawyers going, well, let's go talk about now. Okay, what do we need to put a Band-Aid on first? And then how do we start taking chunks out of whatever the conflict is? Right.
So if the clients want to talk about, like that case I was talking about with Francis, I think our clients, the first thing they wanted to deal with was the real property. So we had a meeting designated for what we were going to do with the real property. And then we moved on after that. So you might have in divorce, real property might be a meeting. Retirement might need to be an entire meeting. You may need a meeting or two about what to do, you know, the children and that type of thing, visitation, custody, even though they may have met with a mental health professional outside of a full team meeting, you still have to go over that, make sure everybody's on point, everybody's on the same page, like Brian said, reading from the same sheet of music. And like I was saying, subsequent to that meeting, the minutes are sent out to everybody. Everybody's got a chance to review them. I can't remember, somebody was talking about a case. Francis, was it you, where somebody'd show up at the meeting and act like they had no idea? Was that you talking about that? I don't remember that. But basically, I can't remember. There's a collaborative practitioner that I remember talking about. The next meeting, somebody would show up and be like, oh, I never agreed to that. Well, here were the minutes, and they were circulated. And you had a day or 2 or 3 days or 4 days, you probably had 2 or 3 weeks, really.
Well, and I think what we've learned from how it's gone sideways is that what we really need to do is create the minutes in the meeting,
right?
Review them in the meeting,
right?
Get them signed off on in the meeting, and then move on. Right. It's way more efficient, and that's what laptops are for.
Right. And so that's one of the, and like I said, well, Francis has brought us back full circle, because like I said at the beginning when I started my portion of this, until you do it one time or maybe 10 times, you don't really know all the pitfalls that you're going to get into. Because Brian and Francis and I have been to lots of trainings, and we've been trained by a lot of fabulous people that have been doing this for a long, long time. So we've heard a lot of pitfalls have already been pointed out to us. But again, until you really get into it and start doing it, like most everything, you're not going to see what's going to work for you. So with that being said, I think that.
Do we want to open it up for some questions?
Yeah.
Do you guys, let's open it up to our physical participants.
Yes, go ahead.
From the lawyer.
Yeah. The question, in case you all couldn't hear it, was how do clients find out about collaborative? Go ahead, Brent.
Well, what I was going to say is we have adopted the Uniform Collaborative Law Act in Alabama. And one of the things that the act requires is that if you are going to be a collaborative advocate, you have to inform the client of all of their options. One of those, of course, being collaborative. So I think that it's kind of interesting that we don't require that of all lawyers in every context. I certainly have adopted that approach. So every client that I see is informed of all their choices. And in the context of divorce, we talk about uncontested divorce, kitchen table negotiation. We talk about pro se mediation. Yes, I do talk to people who come to see me about pro se mediation, because I don't want to take their money if they can go get mediated without a lawyer. We also talk about mediation with lawyers. We talk about collaboration. We talk about litigation. And so the clients are informed. Then I usually give them some other, if they're interested in collaborative, then I send them to a website where they can get more information. I might loan them a book. I want to make sure they're fully educated about what it is and what it isn't. It's not a magic bullet. It's not a magic pill. It doesn't change people's personalities. It doesn't take away the problems that brought you to the conflict in the first place. But it does offer some options and an approach that is very different from the traditional process.
I always enjoy the clients who come in who think that, oh, we'll do collaborative because then I can really control the other side because, I'm just going to, we get this done and I know exactly what this outcome is going to be the second I walk in the door, and it's just a matter of you collaborative to put that through. It never works out that way. And that's one of the first things you have to do is dissuade your client also. Don't come in here with all preconceived notions. This is what it's going to look like. It may look like that at the end, but we're not here to damn things through.
Well, and I think one of the things we've learned through collaborating is that there is actually benefit to parties to sitting in a room together, brainstorming about different options, looking through all the different ideas of how things could be resolved. Because then, after it's over, they don't sit around and ruminate about, well, what would it have been like if we had done this or if we had done that? You've got a financial neutral who can do forecasting for options that are tossed around. So there's a lot more information, and our goal is for decisions to be much, much more well-informed and thought out than is possible usually in a traditional process. Any other questions
in the room? How about on the phone? Any questions from the webinar folks? Okay, not hearing any. Eileen, I
have a question. I don't know if y'all can hear me. This is Samantha Smith. How does it, I know you say you can withdraw from litigation and move into you don't have to start from a collaboration. The litigation can begin and then you can move into collaboration. How, if you are a defendant, can you effectuate that? Do you go ahead and answer the complaint and then move to stay the proceedings, or how does that work?
Yeah, it's in the Collaborative Law Act that can happen, which Alabama has adopted, and that really is the process. The parties
have to answer,
you just file a motion to stay,
Okay.
but the parties both have to agree. So unlike you can file a motion to have your case ordered to mediation.
Right.
You can't have your case ordered to collaboration. The parties have to both be of an agreement that they're going to enter this process. If they're both in agreement, a joint motion to stay. And under the Collaborative Law Act, because the Collaborative Law Act says that is the appropriate method, the judge can have to enter an order to stay.
Great, thank you.
Yep. Other questions?
All right.
I want to follow up on one thing Francis was just saying about the financial neutral. It can be very educational for parties to have all of a sudden, whether it's in a matrimonial situation or a business situation, have their financials up on a whiteboard or on a big screen in front of them and see what they're actually spending and where the money's going, and have that oh crap moment as they look at it and go, we didn't realize this is where our financial problems lay. And then have that financial neutral say, okay, if we divvy things up in a certain fashion, here's what it's going to look like in 5 years. Here's what it's going to look like in 10. You really are getting, instead of shooting from the hip about, okay, what is the right amount of spousal support? What's the right way to divide this bank account? What's the right way to divvy up real estate? You can really look at it and go, okay, this asset's going to be worth X, in 5 years. Where does it make more sense for that asset to go or to be distributed? And you really can get to a far better agreement in the long run.
Well, I guess that begs the question, like, how do you get people to think in terms of their interests? Like, really, that's not a paradigm we live in as traditional advocates generally. And so I think one of the things we just sort of forgot to talk about, there's so much to cover. You really can't understand this process in an hour. But one of the first things that happens in a collaborative process is that the parties are asked to identify their goals. And so their goals, like the participation agreement, become like a central part of the glue that holds the process together. So as options are explored, the options are measured against their goals. And that is a good way to keep people focused on interests and goals instead of just getting stuck in their position.
Are there any other questions?
Can you hear me?
Yes.
Hello? Can you hear me?
Yes, we can.
Okay. This is Shirley Brown, and I guess the question I have is, I do mediations, and a lot of times the court will send mediations, allow parties to go into mediation. With collaborative, how do you, if you're not a party or an attorney representing a party in the matter, then then how would you get into collaborative law? How would you become a part of the process? Is it just the two attorneys who are doing this, or is there a third party neutral who the parties are required to allow to assist them in the collaboration? How does it work in that regard?
Generally speaking, the model envisions one lawyer for each party. There are jurisdictions where collaboration has evolved to the point where each party will have a collaborative lawyer, and they may hire a collaborative mediator to assist. We have never done that in Alabama, not to my knowledge. We have always just followed the traditional model of one lawyer per party. And again, we can't underscore this enough. Anybody who participates in the process has to be formally trained. This seminar is not formal training. This is an introduction. This is not teaching you how to collaborate like you can go do it tomorrow. This is just giving you an idea so you can decide whether or not you want to jump in and get that formal collaboration training.
Okay.
Francis, this is Eileen. If somebody wanted to get that formal training, where could they find information out to obtain that?
The International Academy of Collaborative Professionals has a website, and they keep listings of trainings that are going on around the country. There is a training group out of Washington, D.C. called Collaborative Practice Training Institute, CPTI. They have been here to train with us a couple of times. We've seated a couple of trainings here in Alabama, and I think they're the best. I think they provide the best, most professional, most comprehensive training that's available in collaborative in this country, and they also have a website. If you are interested in that and we get enough interest, we will organize one here in Alabama, but it costs a lot of money. We have to have the commitment of at least 25 or 30 people to pay for it and come to it, to be able to put one on. But feel free to, Eileen, do they have our contact information?
I don't think that went out with the materials that was sent, but we can certainly provide that to them.
Yeah, if you can put that on the website, and we can provide that to the people who are here present. We would certainly be interested in your interest. If that's something that people in Alabama want, we'll try to make it happen. But another thing to keep in mind is this is not the kind of CLE where you go and you go to 1 2-hour block and then you go sit by the pool, and then this is a training you need to participate and stay involved and engaged fully the entire time. If you miss any of it, you'll be lost. Just
like Francis is saying, where you are active and involved the whole time, where you're in, you break out of small groups,
I'm not sure I saw that is at 1 o'clock.
Simulate.
okay. People to mute again.
Yeah, you're getting a lot of feedback. Ask the question.
Okay, Brian and Francis and Virginia, I want to thank you all. I just muted everyone again and then unmuted y'all. So if you just made a few comments probably about 20 seconds ago. Would you mind repeating them? Because we were picking up some background noise. And
oh, yeah, the only thing we said was it was asked if there were any other questions. It doesn't sound like there are.
Okay. Well, I don't think there are, and we're at our 60 minutes. I very much appreciate the work that you all have done. Thank you, Virginia, Francis, and Brian, for a great program and for whetting our appetites about collaborative practice of law. I invite everyone to visit the Alabama Center for Dispute Resolution's website and Facebook pages for more training opportunities. We're at alabamaadr.org. Our next free webinar is set for September 20th, where the topic continues with focus on team, breaking down roles, and we hope that you'll join us. Again, please remember to complete the program evaluation through SurveyMonkey. The code to enter on the survey is 5042. That code again is 5042. For those of you who are attending by webinar, you'll need to enter that into your evaluation. The recording of today's webinar will be posted on the center's website, and we thank you all again for your interest and for attending, and this will conclude our webinar. Thank you.
Thank you.
Great.